Hi there. It's great to have you back on my CryptoQ Media channel. The news that the SEC is appealing Judge Torres' ruling in the SEC v Ripple case has probably made rounds by this point. I spoke with a few of attorneys whose views became viral, and I put out a video shortly after Wednesday's news broke that this was the case, a move that apparently shocked no one. Since CEO Brad Garlinghouse had very strong opinions on the matter, I uploaded a portion of his comments regarding it to my channel shortly after the news came out. I broadcast the video without Jeremy Hogan's statement, despite the fact that he was an attorney. Just so you know, Attorney Hogan thinks the SEC made a huge mistake here. I wouldn't be surprised if the SEC finds out in the end, just like the youth say, because he didn't share his thoughts on the matter and its implications in a fairly lengthy post until after I published the video. Whatever the situation may be, I will only play the video to demonstrate how Attorney Hogan reacted to everything. Still, what a bunch of nonsense. It intends to file an SEC appeal challenging the programmatic sales decision. If it is successful, it will continue to take funding from Ripple without offering any form of protection to anyone. Furthermore, I must pause for a second to elaborate on this for the sake of clarity. When we talk about programmatic sales, we're solely referring to the selling of XRP on Ripples, not on-demand liquidity on exchanges. Consequently, we do not have any knowledge of these transactions. You can have bought it from Ripple without realizing it because it was advertised on an exchange. How about what the hey, possibly it is unimportant irrespective of the deal. Ripple referred to those trades as programmatic sales. It is a term that Ripple created. Because it was the formal name of the litigation, that phrase was used moving forward. The SEC also used it in the litigation, particularly in the initial complaint, so this is all about that. The signed transactions, especially those using Ripple, are very important. This has nothing to do with ordinary people like you and me buying Bitcoin on exchanges. In fact, it couldn't care less. That was totally unrelated to the lawsuit. In this specific case, Ripple is being sued. It seems like we should be concentrating on the specifics of Ripple transactions rather than the ripples between us and you. In addition, XRP has clear regulations, yet, the SEC cannot contest transactions on the secondary market that include regular people like you and me. Thus, we should not worry much. My opinion is that. In any case, I think it's very obvious. Furthermore, he asserts that Ripple would raise the subject of blue sky legislation, which, if passed, would make the SEC's ability to regulate the whole cryptocurrency sector irrelevant. When it comes to estimating risk, the SEC would be woefully inadequate as a stock trader. I understand now. Exactly what the blue sky law was is something I don't remember. I get that Ripple made some valid comments regarding things like post-sale duties and transactions based on blue sky legislation. To elaborate, in the United States, blue sky laws were passed by individual states prior to the installation of a federal president in order to protect the general populace from deceptive securities sales and offerings. You do realize that state laws set the standard before the Federal Securities Act of 1933 was passed. Those celestial rules were the basis. With that stated, I agree with him that that was his main argument. Second, he made it clear that the trial judge cannot reject this appeal since it is an appeal by right, unlike the SEC's previous efforts at an appeal. Okay, take this time at the start of the year as an example. Judge Torres slapped him on the bottom for trying to file an interlocutory appeal, an expedited appeal with the SEC. She didn't think it made sense, therefore she rejected their move. I seriously doubt that it will make a difference, and there are many reasons why it cannot be done at this time. Even though Judge Torres has made this quite impenetrable, I still don't think he can dismiss the appeal. I agree, that's right. Also, I'll take a quick note of Attorney Hogan's third point. The SEC has a very good chance of losing, both statistically and factually. Both Attorney Deaton and I were just raising this subject. When I initially brought attention to the fact that this issue is being emphasized in my video, I suppose I have mentioned that this appeal is taking place. But Counsel Deaton raised the point that, you know, one of the Howey elements was the basis for Judge Torres' decision. Everything must be in order for the Howey test to be satisfied before it can be concluded that a certain transaction constitutes an illegal security transaction. Judge Torres solely looked at the third point, as stated by Deaton. The judge's response was, well yeah, and that's all she needed to do, by the way. The reason behind this is that, as Deaton mentioned, the satisfaction of each prong is irrelevant if any one of them is unfulfilled. If this is remanded, she can simply rule on the other prongs, as we are already aware that there is an appeal. Therefore, it makes little difference to her that she will achieve her goals. That being said, it is expertly written in that style. This, then, is the fourth point, as stated by Hogan. Even if the SEC were to win the appeal, it is likely that nothing would change regarding XRP and Ripple's utilization of it. All that matters is money. His presence of 2 fours in this situation does not necessarily warrant your notice. 2 of his points are considered fours, giving him a total of 8. That was unnoticed by me even after returning to it multiple times. Point 2, number 4, the SEC is required to submit its initial brief by mid-December. He will be informed of the points the SEC is appealing in a couple of weeks. Since XRP is not a security, the SEC will not be able to appeal the order, thus it is important to watch whether they decide to do so. Sure, you can't deny that XRP acts as a security attorney on its own. Hogan, the first attorney I'd ever met, revealed the reasoning shortly after XRP. On July 13th, we commemorated XRP Victory Day last year. He made note of the fact that XRP was ruled not to be a security because the judge's quotation was dicta de CTA. There is no way to challenge her decision through the proper channels because she did not receive the request to rule on the topic at first but later included it. I have shown this on my channel countless times, but the SEC went to even greater lengths by writing an independent statement claiming that XRP is useless computer code. From what I can tell, it was either written for Judge Tor or transmitted by the SEC around the middle of August of last year. No, we will not be appealing that. The fact that XRP is not a contentious security right has been acknowledged even by the SEC. Also, the injunction Hogan stated would simply be the SEC's way of making sure Ripple doesn't break any rules, either the login requirements or Section 5 violations. Fifth, you won't hear back from the appeals court until late 2025 or early 2026. In the summer of 2025, a decade from now, I said that it would take until 2026. I was completely incorrect about that. Sorry about that. Our apologies. Our deepest apologies, Tony Hogan. Truthfully, it isn't. Most people wouldn't notice a difference anyhow. In addition, I am unconcerned for 2 reasons: A, I appreciate your efforts, and B, the average XRP holder will be unaffected. This is important just for you and the Ripple community. Not many people, in my opinion, are upfront and obvious about that. In this particular situation, he proceeds to bring up point 6. No matter how crazy I am, I can't deny that the filing of the appeal and Attorney Gruel's announcement that he is resigning from the SEC occur simultaneously. Your attention in watching my video is greatly appreciated. Click the subscribe button and then tell me what you think when you're done.